Welcome everybody. I am Leonard French, your favorite copyright attorney. We think we've got this right. YouTube has changed up the live streaming system and we no longer have the options to start the stream when I start the stream. And so we had to coordinate like a 3, 2, 1, go kind of thing there. Hopefully we did it. If we didn't, I hope you were entertained. Good morning, good evening, good night, everyone around the world watching me, Leonard French, on your favorite legal news and education channel, Lawful Masses. Thank you for joining me for this absolutely epic verdict. Now, I get to claim a little bit of victory here. I predicted this a year ago when Sony sued Cox after BMG sued Cox. Now, BMG got something like a $23 million verdict, and I was like, what? That seems a little low, but hey, good for Cox. No, this one is $1 billion. So we will take a look at this case. This verdict is only 2 pages long, so we'll talk a little bit about copyright and what exactly happened here, because of course, a jury verdict doesn't tell you anything, so I, Leonard French, your favorite copyright attorney, will tell you what you need to know. Take the music out a little bit here. And maybe we'll pick that back up at the back end. Hello everyone, welcome. This is the Sony Music Entertainment versus Cox Communication case. And this is what happens when you don't obey copyright rules and laws. Now, I think this is a little bit of a harsh verdict. At the same time, I'm not sure how they couldn't have seen it coming. Copyright law and previous cases clearly have said that ISPs need to have a repeat infringer termination policy. So if you have an internet account, I'm pretty sure you have to have one if you're watching this. If you have an internet account and you use it to commit copyright infringement, well, maybe the ISP should be disconnecting you or sending you one of a number of takedown or cease and desist notices, otherwise notifying you that you're supposed to stop infringement, or else they have to disconnect you. Well, companies like Cox, and I believe there was one, who was the other one? Somebody remember who the other one was, just got sued. And Cox also got sued for not terminating repeat infringers. Yeah, RCN just recently got sued, and yet I think there was another one in there as well. For people or infringers or alleged pirates would have dozens of termination notices, but they would never get terminated, or the ISP would receive notices from the music industry or from copyright owners, and they would not terminate them. So how do you get around that? Well, they can't really see who you are if they don't see your public-facing IP address, so this is not legal advice, but maybe find some way to hide your public-facing IP address through a service that won't respond to a subpoena or other request from a music industry lawyer. But that's not necessarily the best way either. I've definitely represented a number of people who tried using VPNs and still got caught somehow. So please, I'm not endorsing piracy. I'm just a lawyer trying to tell you how to protect yourself from overzealous lawsuits like this. So what has happened here? Let's take a look at the actual thing. This is in the United States District Court for the Eastern District of Virginia. This was just decided yesterday, the 19th. So while everyone was out watching Star Wars, a jury in the Eastern District of Virginia was deliberating for the second day in Alexandria before the Honorable Liam O'Grady. That's a name for you. I haven't met Judge O'Grady, but I think he's Irish. I don't know. Do you think he's Irish? I think maybe he's Irish. So the verdict says, we, the jury, in the above captioned action, answer the questions submitted to us as follows. This is how a jury verdict form looks. The jury does not have to explain itself. The jury just has to follow instructions that are tailored to the case by the two opposing parties' lawyers through the judge. They provide what's called jury instructions, and then these are the answers to the questions posed in the jury instructions. on the factors or claims of liability for both contributory, that's one thing, and vicarious infringement, that's a second thing. We would normally call copyright infringement direct infringement. If Leonard French is committing infringement against BMG Music, well, that's direct infringement. But when Leonard does it through an ISP, the ISP gets hit with contributory and vicarious infringement, if that can be proven. So we'll go over how they proved it here. So the first question was, did plaintiffs prove by a preponderance of the evidence that Cox was contributorily liable for copyright infringement? Answer, yes. And then the second question, did plaintiffs prove by a preponderance of the evidence that Cox was vicariously liable for copyright infringement? And they say yes. It says if you answered no, do not answer any more questions. Great. So the third question does get answered. Plaintiffs have asserted infringement claims for 10,017 works. How many of the works did Cox vicariously or contributorily infringe? 10,017, all of them. And then, do you find by a preponderance of evidence that Cox's contributory or vicarious infringement was willful or intentional? And the answer comes yes. Wow. So that's already pretty damning. The jury is saying that after a trial, after hearings on the merits, after a trial before a jury, after whittling down discovery, after presenting only the necessary issues to the jury, that Cox has in fact committed copyright infringement in some way. Now, the underlying allegations were these allegations that they knew of the tremendous infringement of many of their users and did nothing to stop it, did not disconnect users, did not take any meaningful action against these alleged infringers, which is required under the law, under U.S. copyright law. So here's a distinction that you will often see, and people get very worried about this. I get clients calling me all the time who are very concerned about this $150,000 number, because when you get a copyright infringement suit, this is what they put in it. They don't put $750, they put $150,000. But the law is really anywhere from $750 to $150,000 for willfully infringed works. So they then find that the statutory damage award for each contributorily or vicariously infringed work is worth $99,830.29. $99,000 per $100,000 per work. And since there were an odd number of works, not a giant 10,000 round number, but 10,017, they simply divided that into what I guess they wanted to award, which was total damages of $1 billion. Now, of course, Cox has pledged to appeal this. And maybe there is some kind of argument that the damage award is something excessive. Maybe it's just an argument, though. I think I'm going to make another prediction, guys. This is a jury finding. It's very difficult to overturn a jury's finding without there being some kind of clearly erroneous. I don't even know if pardon me, lawyers. I don't remember what the standard is for this. Clearly erroneous or something like that, or against the manifest weight of evidence or something like that. It would be a really high standard to overturn a jury's verdict. So I'm not sure this is actually getting overturned. And if I was Cox, I would be attempting to settle on the $1 billion damage verdict and pay something less so that we avoid further litigation. To me, it's obvious that they committed copyright infringement after not disconnecting people in such egregious circumstances. One more thing I wanted to go over here. It keeps saying preponderance of the evidence. What about reasonable doubt? Well, in a civil copyright case, not a criminal copyright case, we use a different legal standard. So normally there would be a verdict would have to be beyond a reasonable doubt in a criminal case, which is sort of like a 95-5 or a 99-1 standard, where if basically any juror comes up with a reasonable doubt and they hold out, it basically eliminates a verdict of guilty. I think it has to be unanimous in all the states, but not in a civil case. States have different standards for civil cases. The jury might not have to be unanimous. It might not be the same number of jurors, and the standard is preponderance of the evidence, which is more like a 50-50 standard. Each side must put on their case. And this is what's so bad about the piracy cases that I defend. I defend people who are accused of the kind of piracy that got Cox in trouble, but I defend the individuals who get sued by companies like Malibu Media and Strike 3 Holdings. They sue under the same preponderance of the evidence standard. So a defendant in a Malibu Media or Strike 3 Holdings case doesn't have the benefit of beyond a reasonable doubt. And Malibu Media or Strike 3 Holdings don't have to prove beyond a reasonable doubt that they're 99.9% sure that this is the infringer. No, they just have to make the accusation, and then the infringer or accused infringer has to come forward and defend themselves in court and has to get the attention of a lawyer. And the way you get lawyers' attention is usually money, and money is usually a lot. It's a lot of money to get the lawyer's attention in those cases. I try to charge fair fees, but this is not about me. This is about Cox. So let's not get on the soapbox about my cases. Let's keep talking about Cox. So what was it that Cox was accused of? Well, I don't know if you remember, but almost more than a year and a half, almost 2 years ago, we talked about this case where BMG Rights Management and Round Hill Music, and I guess Rights Corp, because they're a party in interest, all sued Cox for this same exact thing. Actually, and here's a whole bunch of supporting people, including the RIAA. You know, everyone's favorite music industry protection organization. Oh, and then here's BMG as well, as another thing. And so they went to the Fourth Circuit. They argued before the judges, and they claimed the same thing, that Cox could be found liable for contributory infringement and for vicarious liability. This is where, after a 2-week trial, $25 million in statutory damages were awarded. And then after this case was decided, the next case here, Universal and a bunch of others, this might not even be the exact same case as the jury verdict here. Let's see. Hang on, let's go back. Because this is in case 950. This is case 950. Okay, so this is what we're looking at here. So then, yeah, they went back to this case and held all of the hearings and discovery and litigation and found them liable for contributory copyright infringement. So their argument was that Cox was aware of specific customers engaging in specific repeated acts of infringement. Cox claimed to have implemented a 13-strike policy before terminating the service of repeated infringers, but actually it never permanently terminated any subscribers. It only lobbed soft terminations with automatic reinstatement, or it simply did nothing at all. So Cox was found liable then for the copyright infringement of its users. And the two things that they found were contributory copyright infringement and vicarious copyright infringement. So let's take a look at what in the world those things are. Now, first, a disclaimer. I'm about to show you Wikipedia. I just lambasted someone on Twitter for citing Wikipedia as a primary source. Mr. French, what are you doing? I'm just trying to summarize for you. If you really want to know the details, the intricate details of what different courts consider contributory copyright infringement, you need to not use Wikipedia as a primary source. What you do is you use Wikipedia as a secondary source and then trace back Wikipedia's cited sources and see what you can find there. That's a beginning. As a legal researcher, I have access to tools. You could also pay for access to these tools as well, but I have access to tools, research tools to search on contributory infringement. And I just don't think a survey of all the different cases over the course of the next few hours would really be that interesting to you. So I'm going to go over it on Wikipedia. But please, I'm just summarizing. This is not supposed to be some kind of legal treatise on contributory infringement. This is a layperson's summary. So contributory infringement is a way of imposing secondary liability. In other words, Cox was not the person that committed the actual direct infringement. But it is a means by which a person may be held liable even though they did not directly infringe. It is understood to be a form of infringement in which a person did not directly violate copyright, but induced or authorized another person to directly infringe the copyright. So the key phrase there is that they induced or caused someone else to be allowed someone else to infringe with actual knowledge. So when I talk to my clients who are getting sued for direct copyright infringement, there's often a second person involved. Sometimes there's an innocent subscriber, and then the infringer is a person behind the innocent subscriber. And so we're often talking about whether the subscriber is also liable, and no, they are not. Not unless they knew of the infringement and continued to allow that person to infringe. It even something as simple as saying, hey, we got a notice and you shouldn't do that, is probably enough to get rid of contributory copyright infringement if that's the first time. But here, Cox got that notice 13 times and still didn't disconnect people. So was it a problem at 1? Meh, probably not. 2? Maybe not. 3 is probably a generally accepted threshold. 4? 5? 6? I mean, do I just have to keep counting here? At some point we get to a number where it's like, okay, yeah, Cox had enough notice that a specific person was being accused of infringement. But, no one's proven anything. It's just a DMCA takedown notice sent with a quote-unquote good faith belief that infringement was seen on this IP address under penalty of perjury. But it's not proven in a court of law. Well, that's true. And if I received a bunch of takedown notices or cease and desist letters from my ISP, and I knew that I didn't do it, I'd probably have to file something in court or respond to the ISP and say, I'm sorry, this isn't me, I'm being falsely accused, and work it out with them. That's not what we're talking about here. This isn't a case where somebody got 13 strikes and fought every one of them. This is a case where they sent 13 notices and there were not 13 instances of a person fighting it or a person fighting those 13 claims. That's ridiculous in my professional and personal opinion. It's ridiculous that someone should have to fight it, but this is the way that the lubrication of the internet has been set up by the U.S. Congress through the DMCA. If we didn't have this system, there would have to be a different system for figuring out copyright infringement. And who knows, maybe the devil you know is better than the devil you don't know. I don't know. You might have to answer that question for yourself. But this was what Congress decided was the lubrication for handling infringements on the internet. So let me summarize. So contributory liability is if I was the innocent subscriber, but I knew that one of my users or tenants was committing copyright infringement and I allowed it to continue to happen. It's not just a black and white question, it's a gray question. It gets investigated. So Cox and the music industry had to have discovery, and they had to hold depositions. They had to ask questions under oath, and people had to respond, and they had to work through exactly what was the contributory infringement. And that's what the problem was, is that there were 13 strikes and still no disconnections and all that. So then there is a second theory of liability. Normally, you would just need one theory of liability: direct infringement, contributory infringement. But no, they went to vicarious infringement, which is something you do not see in copyright law very often. You see it accused a lot, but you do not see a verdict on it a lot because it often gets dropped because it's very complicated to prove. The difference is that vicarious liability is like respondeat superior I realize it doesn't help you very much if you don't know what that Latin phrase means, so let's continue. The doctrine of respondeat superior is that your employer is responsible for the acts of an employee acting within the scope of their duties. So hear me out for a moment. I'm going to get back to copyright infringement after we talk about labor law. If you are an employee acting within the scope of your responsibilities, meaning you're doing your job as opposed to intentionally not doing your job while you're supposed to be doing your job. So let's take a delivery driver. Let's say that Leonard French owns a delivery company. I don't know what we're delivering, anything. Professor Farnsworth dolls. And in making the deliveries, my employee who is properly doing their job, who is actually going to a delivery in the company car and otherwise is sober and everything, gets into a car accident or a car collision. The employer is going to be held responsible for the employee's car collision. So hopefully, me as the employer have insurance for that and everything. If the employee gets out of the car, goes into a McDonald's, buys lunch, sits down, and then punches somebody in the face, the employer is probably not liable for that. The person is likely on lunch, is likely not representing the company in his official duties of buying lunch and sitting down and eating, and in punching somebody in the face while they're in that situation, they're likely outside of the employer's vicarious liability. This is not a perfectly clean example. I'm sure some labor law attorney out there knows better than I, and maybe there's some jurisdiction where you could still make a really good argument. But that's the gist of it, is the difference is the threshold of when they're doing their job versus when they're not doing their job. There's more to it, but that's where we're going to stop with our definition for now. So back to Cox. Now we have to apply this labor law thing to copyright infringement. So when would Cox be liable vicariously? It would be when the users are acting within the scope of Cox's permission. So here, Cox has effectively refused by their actions, effectively refused to disconnect repeat infringers that they are actually aware of. They have more or less given permission. It's tacit permission. It's implied permission. But it's permission that is actually there because they're literally not disconnecting people, even though they know they're supposed to at that time. So when you get the 13th copyright notice and you send the 13th copyright notice off and you have to do a soft termination and then an automatic reinstatement, you know that person has been accused of a large amount of copyright infringement, and you know that you're supposed to terminate that person permanently, and you're just keeping the money and the customer so that you can keep the money, and the customer will keep paying you. So you're benefiting as the employer, you are benefiting and profiting financially. So someone has a financial interest is often a factor in vicarious liability. So the ISP has a financial interest and is benefiting from the copyright infringement and is not taking steps to disconnect the person. That's what we call vicarious liability as well. They're very similar. The underlying claim is exactly the same, that they didn't just disconnect. It's the legal theory of liability. Not only did they contribute to it by not disconnecting them, but they also profited from not disconnecting them, making them liable for vicarious liability. Now, the vicarious liability claim is the more tenuous one, and on appeal, maybe that's the easier one to overturn, but I don't think they're getting out of the contributory liability verdict at all, and they will owe some portion of this $1 billion to the music industry, unless the music industry really thinks it's a good idea to just nail Cox to the wall with the $1 billion. You'll usually see some kind of further agreement. We'll agree to pay the money now instead of fighting it for years, and then you'll... But the RIAA and the rest of the recording industry are basically independently wealthy organizations. They can afford to wait for their money. No one really is going to suffer from not having that money right away. Maybe someone will consider themselves to be suffering, but I think that's a high-quality problem and not a real problem. So what do you think? Do you think that Cox should be fined or hit with a $1 billion verdict? That's 1,000 millions. Think of how much each of us struggles just to become like a millionaire, because that's like a nice round number to think of for retirement, right? Well, you have to do that 1,000 times. That's like 1,000 lifetimes of people really working hard. And then even then, many people don't have those kinds of opportunities, especially around the world. This is an infinite amount of money compared to what any one person, any one average person makes, even in a first world or what did Factfulness call it? The first world countries were not called. They were like tier 1 or something like that. So people who made more than $4 a day are the richest people in the world, the 25% richest people in the world. Anyway, so go read Factfulness. That's a real good one. But also, let us know what you think of this jury verdict. Let's take a look at it one more time for anyone who is filtering in. Here is the jury verdict for $1 billion against Cox Communication. It was Sony and BMG and the RIAA. It was everybody. And so the jury found them liable for both contributory infringement and vicarious infringement and considered it to be willful. And so hit them with $100,000 per work, rounded down so that the amount per infringement times the 10,017 works equals a total of $1 billion. So I thought that was really remarkable, and you might like to see that right away. And instead of taking the time to shoot it and edit it, I just thought we would go. So I hope you enjoyed that. That is all I have for you today. I look forward to seeing you in videos that drop and on our Sunday show at Lawful Masses on Twitch, twitch.tv/Lawful Masses at 10 a.m. on Sunday Eastern Time. Thank you very much to our patreon.com/LJFrench and sponsors.com/law supporters. At the $50 level, our December supporters are Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Rumble in the Bunghole, and Cute Grills in your area. And I'll put everybody else in the description below. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney. You have a great Friday, the weekend before Christmas. Everybody, there's so much love in the air. Just have a good one.